morning, everyone. Welcome to our webinar on corporate governance and in particular responsibilities for directors. So my name is Michaela O'Connor. I'm a senior associate in LegalVision's corporate team, and I'm joined today by my colleague, Anthony Satti, who is a practice group leader in our corporate team.
Morning.
So thank you, Anthony. And apologies, Anthony's name is coming up as Michaela O'Connor, but his name is Anthony Satti. Now, before we begin, a couple of quick housekeeping items. So you will receive the recording and the slides in your email at the end of the webinar. You can also submit questions in the Q&A box, and we will answer them at the end. So you can submit them throughout the webinar as they come up. And there will also be a feedback survey at the end of the webinar that we'll ask you to complete. Now, there is also, all attendees are eligible to receive a free consultation with us to discuss how we can help with your contracts or any of your other legal needs. So you can actually request that at the end of the consult. You just need to provide us with your contact details in the survey that appears at the end of the webinar. Now, today what we will be discussing is firstly the role of a director. Then we will go into the general duties under the Companies Act. We'll go through some common law duties and then other sources of duties and the consequences for breaching those. And as I said before, we will answer some of your questions at the end of the webinar, so please do submit them throughout the webinar in the Q&A box. Now, I will first begin by going through the role of a director. Now, the focus of this webinar will be to outline the main director's duties, what's best practice to meet those, and what the potential consequences for non-compliance are. So the first thing to go through is just the general company structure. Now, in that structure, you do have directors, shareholders, which we sometimes refer to as members, and sometimes a company will also have a secretary. Now, whilst the company is a legal person, it does actually need people to act on its behalf. And in most circumstances, that will actually be the directors, because they're the ones that are usually negotiating contracts, signing agreements, and enforcing rights against others. Now, directors may exercise all the powers of the company, except those that either the Companies Act, company shareholders agreement, or the company's articles actually require to be exercised or first resolved by the members, so your shareholders. Directors will be responsible for managing the company and dealing with its affairs. So, for instance, making sure that your company accounts and reports are properly prepared. And some directors there's two types of directors that we usually refer to. So those that work in the business, which are called executive directors, and then others which just attend directors' meetings and contribute to decision-making, which is what we refer to as non-executive directors. Now, decisions that directors will typically be making are all of your day-to-day decisions and operations of the company. So as I said before, entering into contracts, hiring people, leasing premises. They can also be involved, as you'll see on the screen, issuing shares in the company, declaring and paying dividends, and authorizing the company. So for instance, taking out a loan or giving a loan. Now, in the course of undertaking all of these obligations, directors will have duties that they have to comply with. So some of the main sources of these, the first is under the Companies Act. So there's actually a set of 7 main directors' duties, which are known as general duties, and we'll go through those in a minute. Then there's also what we call common law duties. So this is duties that the law has actually developed over time, so through court cases, and we sometimes actually refer to these as fiduciary duties. And then there's other duties under other statutes. So for instance, insolvency laws or environmental and health and safety legislation. So I'll now hand over to Anthony, who will go through some of the general duties of a company director.
Thanks, Michaela. As Michaela has mentioned, the Companies Act here in the UK sets out very specific duties that directors need to comply with. A lot of these duties actually reflect duties that have developed over time in the courts, but now they've been codified within the Act. So the first one we'll touch on is your duty to act within your powers. So as a director, your powers sit within the company's constitution. The company's constitution constitution is made up of the articles of association and any resolutions and agreements that are made by the shareholders and directors that affect the articles of association. And so you need to act within the confines of those documents. So, for instance, let's suppose that your constitution required a director to seek a shareholder approval for the appointment of a new director. If you fail to do that, then technically that's a breach of your duties. The second one, and arguably probably the most important, one of the most important duties of a director is to promote the success of the company for the benefit of all members, members being shareholders. And in making that and kind of complying with that duty and making sure that you are acting in a way that does promote the success of the company for the benefit of all shareholders, the Act requires you to also take into regard other things, which include any long-term consequences, the interests of your employees, interests of the company's business relationship with suppliers and customers, the impact on the environment and community, the impact on the reputation of the company, and the requirement that you have to act fairly amongst shareholders. So really, the primary, the thing to take away from this is that your primary obligation is making decisions for the success of the company for members, but you can't be acting and making those decisions within a vacuum. You do need to take into account those other listed factors. Now, not every decision is going to require you to make or consider every single one of those factors, just judging on the particular circumstance. And again, the overriding interest is that to the members as a whole. Now, unfortunately, the Act is a little bit unclear as to what success actually means. The UK government has stated ultimately that success probably means the long-term increase in value of the company. As a matter of good practice, it's always important that, as a board of directors or as a single director, that you are somehow kind of documenting that you have taken into account those factors in making certain decisions. And generally, it's good practice that in board minutes or board resolutions that you are kind of noting that you have taken those factors in the relevant section of the Companies Act, which is 172, in taking and making a particular decision. Now, there's an interesting overlap with the way in which that duty then extends or interacts with a duty to creditors, but we'll touch on that in a little bit of a moment. So, an example recently, which is quite topical, I guess, in this day and age where we're really concerned about climate change and taking care of the environment. There was actually a recent attempted case by the non-government organisation Client Earth against Shell, where they were trying to bring an action against its directors for breaching that primary duty because in essence, their argument was around the directors of that company failing to address Shell's climate change risk management strategy. Now, the court in that particular case didn't uphold the claim, and I think a lot of that came down to the way in which that Client Earth ran their arguments. But I think that it is something, though, that'll be quite interesting to see over coming years, as obviously climate change is such an important aspect of our society going forward. So kind of watch this space. The other kind of the next slide, we've got the other duty to exercise independent judgment. So you basically always just need to make sure that you're not acting ultimately under the influence of some other third party. You're using your own thoughts to come to a decision. Now, practically speaking, obviously, directors are very much reliant on the advice of third parties like lawyers and accountants in coming to a decision. So the idea, however, is that each director needs to evaluate that advice and then ultimately exercise their own judgment in coming to a particular decision. I'll hand back to Michaela.
Thank you. So the next duty, which is the fourth duty, would be the duty to exercise reasonable care, skill, and diligence. Now, under this duty, there's actually two elements. So this is where directors need to act with a degree of competence, and there's two elements that will usually be looked at for this. So the first is what we call the objective standard. So this is the general knowledge, skill, and experience that one can actually expect all directors to have, not just a particular director. But then there's also what we call the subjective standard. So this is actually relates to any particular expertise or skills that a particular director might have. So for instance, if you were an accountant, you might actually be held to a higher standard in relation to financial matters than someone who was not actually an accountant. So using that example, say if a director had failed to deliver accounts to Companies House on time, that could actually be a breach of this duty for any director because it would have fallen below the standard that one can actually expect of all directors. Now, in the same instance, say that one director was an accountant and they'd actually failed to disclose a particular piece of information that they ought to have known due to their accounting experience. In that situation, they would actually be held to a higher standard than a director who is not an accountant, and they could actually be breaching this duty in those circumstances, whereas someone who was not an accountant might not actually be in breach of the duty. So there is actually a real life example of this. It's a case called Dorchester Finance Co. versus Stebbing. So this was actually a claim by the company, Dorchester Finance Co., against two of its directors who were qualified chartered accountants. Now, in this situation, those two directors were actually signing checks which were blank at the request of another director to then later fill in at a later date. Now, in this circumstance, the court actually found that those two directors who were accountants had to actually display skills that would be reasonably expected of persons with their knowledge and experience. And in this situation, they had been negligent and were held to be in breach of this duty. And the fact that they were accountants actually contributed to that. So it's quite important, someone's background, as well as just the general objective standard for all directors. Now, the next duty is the duty to avoid conflicts of interest. So this actually comes up quite frequently. Now, as it says, you must avoid situations that create conflicts of interest with the company's interests. Now, an interesting example of this, again, it's quite easy to explain it with a real life example. So there was a case which was called Industrial Development Consultants versus Cooley. Now, this was where a managing director of the company had actually been negotiating to build depots for a third party in their role as a director of the company. The negotiations were unsuccessful, and then subsequently the managing director had actually resigned, but on a false premise. After the resignation, they then had secured the contract for themselves personally. Now, in this case, the court had actually concluded that the director put themselves into a position where their position conflicted with their position personally, and it was actually found that they had to pay back the company for the profits which they would have otherwise made if they had been awarded the contract. So it's quite important to make sure that you are acting in your position and your role as a director, as opposed to any conflicts you might have personally. Now, obviously, conflicts might arise quite frequently, and as a director, you can actually seek the authority of other directors, provided they are independent and have no interest in the situation. So in that instance, you could go to the other directors. They could actually authorize the action, provided you're not voting on that situation, and that they actually have all the information to make an informed decision. And in that case, if they do authorize it, then there might not be a risk of breaching that duty. Now, the next duty is the duty to not accept benefits from third parties. Now, the duty, it says what it says, is don't accept benefits from third parties. Whilst that is the case, it doesn't actually prevent you from accepting benefits from the company or an associated company. So for instance, if you had a personal service company and they are then providing services to the company, you could get that approved by the other directors. A real life example here would be if you are an electrician you visit a job as a company director to speak with a potential client. So it's similar to the previous case that I just touched upon. But in this case, you secure the contract for the company. After talking to the potential client, it then turns out that they don't really want. Oh, sorry. You're an electrician. You go to the client to secure the contract for the company, but the client doesn't actually want to proceed with the company, and instead they want to offer you the contract personally. Now, in this situation, if you accept that contract personally, you could actually be in breach of that duty because it's a benefit that you obtained in your position as a director. Now, there is a real life example of this. It's a case called Towers versus Premier Waste Management. So in this situation, Mr. Towers was actually a director of Premier Waste Management, which is the company. He'd actually received a loan of some excavation equipment from a customer of the company for his own personal use. So it wasn't done through the company. The equipment was only used for a couple of months, but then it was actually held on Mr. Towers' personal property for quite some time. And it was also repaired at the cost of the company as well before it was returned. Now, as you can imagine, the customer then raised a dispute because they wanted to claim a higher charge from the company directly. And in this case, the company had to pay a higher charge to the customer, but then they sought to recover those same charges from Mr. Towers personally on the basis that he'd breached the duty to not accept benefits from third parties in his role as a director. So it was found that Mr. Towers had to pay back the company the cost of hiring the equipment. Now, the final duty under the Companies Act is the duty to declare an interest in transactions with the company. Now, this quite frequently actually intertwines with the duty to avoid conflicts of interest because it's along the same sort of lines. But basically what this duty says is that if you do have an interest in any transaction, you do need to declare it to the other directors. So if you don't declare it, you would be in breach of this duty, as well as also possibly breaching your conflicts of interest duty because they do tend to cross over. Now, one thing to be aware of with this duty is that it does also apply to situations where you don't have a direct interest in the transaction that's being proposed, but it might be that someone that you know does. So for instance, if your brother was selling a piece of land to the company, then that's an indirect interest and you would actually still need to declare it to the other directors to not be in breach of this. So that goes through all of the 7 main duties under the Companies Act, but there are also some other duties to be aware of. So I'll hand back over to Anthony, who will start going through some of the common law duties.
Thanks, Michaela. So, as I kind of mentioned before, the duties that are in the Companies Act actually have largely a foundation within common law, and it's the case now that if you do breach any of those duties, then the courts will interpret the breach of those statutory duties still with reference to much of the common law and cases that have been developed in the courts. There are, however, some additional duties that have developed over time. So, for example, as mentioned on the slide there, a duty to inform yourself as a director on all of the company's affairs and to maintain a sufficient knowledge and understanding of the company's business to always discharge those duties. There's a duty not to account or profit, in essence, from your directorship, and that you need to essentially, if you do account to the company, that profit, unless it's the case that the relevant transaction, etc., that you are profiting from has been approved or authorized by the shareholders or is otherwise in accordance with the company's articles. There's a duty of confidence, so in essence, to maintain the confidentiality of information that you're receiving as a director, and again, not using that to your own personal advantage. There are, however, two fairly interesting common law duties that have come up, and which which are in essence the creditor duty and the duty to disclose wrongdoing. Now, one of the things I wanted to mention first up was that these common law duties, all of these common law duties, are based upon the fiduciary relationship that you have as a director to the company, and in essence, a fiduciary relationship and the duties that come from that is ultimately the obligation for you to act in the best interests of the person that you are the fiduciary of. So in this instance, your director, your fiduciary relationship with the companies is to act in the best interests of the company. Now, the creditor duty is quite interesting because, as you may have, you'll remember from what I said before, we have that overriding interest as directors for the success of the company, for the benefit of all of its members. And interestingly, one of the factors that were listed in that section of the Companies Act was to take into account the relationship that the company has with suppliers or potentially creditors. Interestingly, the common law has kind of modified that duty slightly, where the company is about to go insolvent or is insolvent. And in essence, the case law on this, which the main case is known as BTI versus Sequana, I think I've pronounced that correctly, which in essence, in summary, basically what it requires is that where a company is insolvent or about to go insolvent, then directors ultimately need to prioritize the duties or the interests of creditors over the interests of shareholders. And so the idea is to make sure that their primary objective is maximizing the assets and not doing anything to adversely affect the company's assets in order to be able to pay off creditors that the company has, rather than trying to just continue to operate or for the benefit of the shareholders or do things that are for the benefit of shareholders. So stuff like making sure that they're taking actions to minimize any losses, or taking actions not to deplete the company's assets or make preferential payments. Now, the important thing to note in all of this is that this creditor duty is not something that is directly owed to creditors. It is still a general duty to the company itself. And it's the cases have developed so that this particular duty is not something that you can simply ratify or get shareholder approval for or other director approval for. Like it's kind of like more of an absolute kind of obligation. Now, the interesting thing is if you do breach that duty, then there's that potential for you being held personally liable for the debts, additional losses, etc., that have been incurred to creditors, and you could be personally liable for that. The duty to disclose wrongdoing is something that's developed more in recent years, and it's ultimately a duty to disclose to the company any wrongdoing that you yourself have done as a director, or that any other person has done to the company as far as it affects the company that you become aware of. So an example, of this that recently came up was in this case called Item Software versus Fasihi. And in that instance, one of the directors was negotiating a distribution agreement, or the company was in negotiations for the renewal of a key distribution agreement. The director was encouraging the company to be very aggressive in negotiations, but at the same time was having side conversations with the distributor, in essence representing to them that they would set up their own side business, the director, and enter into a distribution agreement with that under that side business with this party. And so the court in that instance definitely said that was a failure to disclose their own wrongdoing, but also it was just a general breach of their duty to act in good faith and in the interests of the company.
Perfect. So now I guess that there are other obligations that you should also be aware of. So we've gone through general directors' duties and common law duties, but other laws and regulations do actually put some obligations on companies and their directors as well. So there's a few on your screen at the moment. The first major one is work health and safety laws. So this does actually require companies and specifically directors as well to ensure that the company is operating safe working practices, amongst other things like chemical regimes and environmental protections. There is also anti-bribery legislation, which does actually impose potential criminal penalties on companies and their directors as well, if they are engaging in bribery or corruption in operating the business. Now, that can also extend to failing to prevent those practices from happening in the company as well. Now, there are also financial services laws. So under those laws, where it can actually be shown that the director was involved in a breach of the financial services laws, they can actually be held personally liable for that as well. Now, there is also what we call the Equality Act. This doesn't just specifically relate to directors, but anyone accused of discrimination can actually be pursued under the Equality Act. So that can extend to you in your position as a director as well. There are other statutory duties. So, for instance, under the Companies Act, which you do need to comply with for the company. So these include meeting filing requirements with Companies House, as well as updating any company information with them on time, filing your confirmation statements on time, and any annual accounts as well. And generally other obligations that you should really be making sure that you comply with to make sure that you do comply with those directors' duties is broadly just having good corporate governance. So this includes keeping a record of all your minutes of meeting, resolutions, making sure that you're actually regularly holding directors' meetings, as well as annual general meeting of the shareholders, or it might even be more frequently than that if it's prescribed under your articles to be. And then also ensuring that any meeting that is held is actually called in accordance with the Companies Act, your articles, your shareholders' agreements, and making sure any voting is in accordance with that as well, because your ability to act in the role of a director really comes down to those three, the act and the two pieces of your articles and shareholders agreement, if you have one. And it's really important that you're making sure that you're complying with all of those. Now, I will just hand back over to Anthony, who will go through some of the consequences for breaching as well.
Thanks, Michaela. So, if you do breach your director's duties, depending on the particular piece of legislation or common law duty, etc., it depends. But ultimately, there will be either some sort of civil penalty that's imposed on you or criminal penalty. So, for example, it may be that you need to for example, if you've made a personal profit from breaching that particular duty, a court might order you to repay to the company that particular amount, or if you've caused the company a particular loss, then again, a court might order you to pay the company compensation for the damages that you've created. If you've maybe taken company property, then returning that property. If it's something that's kind of an ongoing breach, then you might have an injunction that's ordered against you by the courts. And then obviously, in the criminal context, it could be fines or imprisonment. In terms of actions that could potentially be brought against you personally as a director, it will normally be the case that it is the company that is bringing that action against you. However, there are circumstances where shareholders might be able to bring a claim against you under what's known as a derivative action. Liquidators also potentially are able to bring claims against directors personally, particularly in that context, the context obviously of insolvency, and whether whether you as a director has potentially breached particular duties, and therefore for the ulterior purpose of the liquidator attempting to get you to pay or repay some of the company's assets or monies, or be responsible for certain debts that have been incurred. Other kind of remedies or consequences might be, for example, if you've entered into a service contract for your directorship, then potentially a breach of contract under that and damages that might flow from that. If you've breached, you might might be removed from your position by the other directors or by the shareholders in accordance with the Articles of Association, or potentially a shareholders agreement, or depending on the severity of your actions, that you might end up being disqualified under the company's directors disqualification act. So look, yeah, that's kind of mainly the consequences and kind of penalties that we can look at. That actually concludes the main part of our webinar at the moment. And as Michaela kind of mentioned to you at the start of the webinar, we do have a UK Directors Duties Guide that you're able to download and will be available to you after the webinar finishes. We also have another upcoming event, which we would love for you to also join, which is on business divorces, exiting directors and shareholders from your company, which is on the 30th of July at 11 a.m. The link is there, legalvision.co.uk/events. Please, by all means, join us and register to participate. Now we're going to answer some of the questions that have come up during the webinar shortly, and by all means, please submit any other additional questions that you might have. While you're submitting them, I'll just kind of take a minute to tell you a little bit about LegalVision's membership. By becoming a LegalVision member, your business ultimately gets unlimited access to a team of specialist lawyers for all your business as usual legal needs. In essence, it's like having an in-house legal counsel for your business at a fraction of the cost. Our team can assist you with unlimited document drafting and reviewing of business contracts, you receive unlimited legal advice consultations, and unlimited domestic trademark registrations and much more. As a member of LegalVision, you really don't need to worry about the cost of lawyers again. As I said, it's like having an in-house counsel to take care of all of your business as usual needs. If you want to learn more about our membership, please you can request a free consultation when the survey appears at the end of the webinar. Now we'll answer some of your questions. I'll take one of the first ones. So we had a question from Will. Is there a difference in terms of what's considered a conflict of interest for a non-executive director versus an executive director? The answer is no. The rules and the duties that apply equally across those forms of directorship. Another question that's come through is, can a director delegate their duties? The answer is yes, you can. And that's often the case that there's a specific provision in the company's articles that will deal with this, but generally under common law as well, you are entitled to delegate. The thing to note there is that just because you've delegated some actions to a person doesn't mean that you're absolved from complying with your duties. So you as a director still need to supervise that person, and you're ultimately responsible for that person's acts or omissions that you've delegated to.
I think that also leads into another question, which was, if a company is made up of multiple owners or directors, but there's an internal structure in place, so MD, FD, who's ultimately responsible, or is it split across the directors? As Anthony was saying, you can't actually delegate your duty yourself as a director. So even if you do have those different roles, you should still be across something and making sure that you're aware of everything that's happening in the company, because you could still be held liable for something that does happen. It just might be that your liability is different to another director depending on the circumstances. Do you agree with that, Anthony? Yeah. Another question that came up was, when might a person be considered a shadow director, and what problems might this raise when a company is in financial difficulties? Now, it is quite difficult to specifically say exactly what a shadow director is, because it does definitely depend on the circumstances of that individual. Now, for anyone that isn't aware, a shadow director is someone who could be considered a director at law, but might not actually be registered as a director with Companies House. And in that situation, it will come down to the circumstances of their responsibilities for the company and what they've actually been doing for the company. So, for instance, if they are making day-to-day decisions, they are actually running it, and the other person who's registered as a director with Companies House isn't really doing anything, they could actually be considered the shadow director and could be held to the same standard as someone who was the director for the company. So in the situation where the company is facing financial difficulties, a shadow director could actually be held to the same standard. So it's something to definitely keep in mind, even if you're not registered as a director with Companies House. And I think, is there a couple other questions there?
Yeah, I'll answer one of them. Look, there's another question around where directors stand to gain from a decision. Do you have a duty to pass decisions to shareholders? I think I'll answer that question kind of in a little bit of an indirect way, which is kind of because as that kind of touches more on the point of ratification. And ultimately, is there some kind of defence that's available to directors where they are potentially breaching a duty? So in terms of ratification specifically, under common law, the shareholders of a company can ratify a director's breach of a fiduciary duty, or basically affirm a particular transaction or action, which would then release the liability, a personal liability of the director. There are some exemptions around this, so, for example, around fraud or oppression, or oppression against the minority or dishonesty. That common law position has actually been adopted within the Companies Act, and so there can be again a ratification of a decision through shareholders. As long as that director or any of their connected persons aren't also in essence voting on the particular resolution. Again, the kind of same exceptions apply in terms of if the action was fraudulent or illegal, then that simply can't be ratified. There are also, and to be fair, there is kind of in a segue, it's a little bit of a deviation from the question, but I'll add the information nonetheless. Is that also it's a case that for certain breaches of duties, you can in essence have a defence that might be found in your favour in a court case. Basically, for a court might decide that decide that they relieve you from liability from breaching those duties if the court considers that you've acted honestly and reasonably, considering all of the circumstances, and that you should be fairly excused. I'll just see if there's any other questions that have flown through.
There is one which was, is it advisable to have a shareholders agreement to reduce the chances of disputes between shareholders and directors, particularly how shares can be disposed of, which isn't really relevant to this webinar, but yes, a shareholders agreement is always very important to have. Normally, we do try to put a lot of the decision making in your articles of association, but you might also need a shareholders agreement to detail generally when things the shareholders might want decisions to actually come to their level as opposed to just being decided by the directors. And it's always a good idea to have those documents in place and have a bespoke version for your particular company. So we would recommend that.
Okay. Look, there's some other questions that have come in, which aren't really relevant directly to the questions of directors, but as we've kind of said earlier, you're more than welcome to book a free consultation with us, and we can try and deal with some of the answers there. I did see that there was a follow-on question from one of the other questions that we raised around shadow directors. And the circumstances where you have 3 appointed directors, but also internally a managing or somebody that you do nominate as a managing director. Ultimately, again, it depends on the circumstances. If the managing director is actually the director and exerting influence and control on the way in which the board is actually run, then I guess there could be a circumstance where that is maybe potentially that person is considered as a as an actual shadow director. I think interestingly, the titles are sometimes used differently within different industries. So, for example, in an interior design firm, there might be an interior design director or a design director, but just because they're labeled the word director doesn't necessarily mean that they are, or that they will be deemed to be a shadow director. It all depends on the circumstances of that person's influence and control of the business and company, and whether they could then ultimately be considered as a director. Look, I think that we might leave it there. Thank you, everybody, so much for your time today and for joining us. Again, please, if you could fill in the survey at the end of this, at the end of the webinar, which we'd really appreciate. And as I said, please, by all means, take up our offer to receive a complimentary legal conversation or consultation with us to discuss how we can help you and your business. Thanks so much again, everyone, and have a lovely day. Bye.
Bye.